professional Krasker real estate attorney for 34 years in Palm Beach County. I started a company called Trident Title and a joint venture with Performance Title. I used to come here on a monthly basis during season. Now I've sort of just come as requested. We're hopeful that many of you will consider us for title work. That was the understanding when I started the lecture series, and I kept up my end, and we're woefully short on your end. So more closings are needed to keep the learning train going. I've been asked to talk about the Condominium Rider today, and it's radically changed, but I'm going to go from top to bottom so that everybody can understand each of the paragraphs. If you have questions, stop me, but my suggestion is to take notes on the actual rider, and then you can scan it into your desktop, so when you're next filling out a condo rider, you have a document that's filled out correctly, and you can look at your notes to see if you have any questions about any paragraphs. I think the first two paragraphs are pretty self-explanatory, although I always have agents that get stuck on the first one. The association approval. Who's responsible to start the process? Anybody?
The buyer.
No, the seller.
Seller.
The seller is supposed to notify the condominium association, send a copy of the contract, and send over the application to the buyer or buyer's agent. You should have already, if you're a listing agent, you should have already spoken to the management company. You should know everything about the association at that point. And you should have already gotten the application to be able to forward it along to the buyer. But no, paragraph 1 is quite clear that it is the seller's responsibility to initiate the approval process. You need to know up front what the rules are in the association. I always suggest to my agents is to contact the management company prior to getting the listing to know what's going on in the building. Ask for the last 6 months condominium management meetings or board of director meetings so that you can forward those on to the other side. Some people ask for 12 months. I'll explain why later on with the rider, but I think 6 months to start is pretty sufficient. What you're trying to do is figure out what the board is talking about. Are they talking about special assessments? If there's been any reference to a special assessment in the last 12 months, you are required to notify the buyer. If you do not notify the buyer and there's a special assessment that is issued based on the conversations, your seller is going to get sued for the amount of the special assessment, and they will turn around and sue you. So you've got to take this seriously. When you're talking to the condominium association, you want to find out what types of information. Anybody?
You want budgets?
Budget for the
Financials?
for the actual year that you're selling. You want the last year's
Reserves.
financial statements. You want the reserve statements to know what's in reserve. What else do you want?
Milestone if it's needed, reserve study if it's needed, the 12 months that you talked about, the 12 months of
Good.
Board meeting minutes.
And then all the other governing documents, right? You're supposed to have a
Rules of
copy of
regulation.
all the governing documents and any amendments there too. That includes the Declaration of Protective Covenants, the condo. Yeah,
12 months of board meeting minutes?
yeah, it's right here on paragraph
Milestones.
3C1. It says the definition of a pending special assessment is anything that's been on the agenda or reported in the minutes of the association within the 12 months prior to the effective date.
Yeah.
So if 10 months ago they talked about doing a roof assessment, roof special assessment, and you don't have those documents to tell them, and there's a roof special assessment that ends up coming in between the contract and the closing date, you are liable for it.
Can a special assessment ever not be in the minutes?
It is a possibility if there's an emergency, so, you know, they don't talk about it for 6 months prior to, but, you know, after you sign a contract, all of a sudden, the water starts gushing into the penthouse units, they're gonna have to do a roof assessment, period. But what you have to prove to the buyer is that you didn't know, and it wasn't noticed in the minutes or in the notice of the board minutes for that period of time. But the governing documents are basically the declaration of condominium, the articles, the bylaws, the rules and regulations, and any amendments thereto. You've got to get a package of those from the association. They might not give it to you as the listing agent. You might have to have your seller on the phone with you when you call the management company. The management companies do not like to speak to the buyers. They don't want to get sued, and they don't want to kill a deal. So they talk to the seller gets all the information, the seller passes on the information to the buyer. There are some helpful management companies who have put all of these in a Dropbox for people, and you can just forward it on. My advice to you is when somebody calls for a showing, send them all the documents in advance. That way when you prepare a contract, you can check the box that says the buyer has received all this, the buyer is aware of this. And you end their 3-day right of review before the inspection period even starts. Okay? So again, paragraph 1, seller starts the process, buyer must diligently pursue. For those of you who are representing buyers in this process, I have had sellers who turn around when the buyer tries to cancel the contract at the end of the inspection period and say, I'm not giving you your money back. You never even applied for the membership. You were required to apply within 5 days of the effective date. I would like to see a copy of your application before I send that $700,000 back to you. That's a very uncomfortable conversation to have with your buyer when they say, oh, you didn't put that on the critical date list for me. I didn't know I had to do that. I thought I had 10 days inspection. I wasn't going to do anything before then. So what do you need to do? If you have a buyer who doesn't want to apply until the end of their inspection period, in paragraph 1, you need to put in that blank within 11 days. Let them have their inspection period, and then on the 11th day, let them apply for membership. But if you don't change that, you could end up losing their deposit for them. Again, I said, you really want to talk to the management company in advance. One of the things you want to ask them are all these questions in paragraph 2 that people call me up and say, hey, what do I put in here? Do they have a right? Does the association have a right of first refusal? Do the members have a right of first refusal? And I say, I don't know. Did you get a copy of the declaration? No. So you want to get those, and you want to specifically ask the manager, does the board have a right of first refusal? Does everybody know what that means? Yep.
Can you please tell me what's first refusal?
Right of first refusal means if the board gets an application for a buyer at a price pursuant to the contract, and the board says, you know what, we don't like this guy. He's bad news, he was a problem for a building down the street, we don't want him in our building. The board has the ability, or may not have the ability, to pay that amount of money and own that unit themselves.
Oh,
and then
okay.
remarket it to somebody else.
Thank you.
And the same thing for members. I don't know how many of you do work in West Palm Beach, but there's a commercial building called Esperante that has 8 units on the top. They're condominium units, but they're built 2 levels like a townhouse. And there are 2 people who each own 2 units. And each of them want to own the entire area. So every time one of the other units comes up that they're going to sell and they submit a contract offer, both of the other people say, yes, I will pay that. I am going to step into the shoes of the buyer. And then they fight with each other and realize that nobody's going to get to do it because neither one of them will let the other one have more. It's great. Okay, so paragraph 1 and 2, again, pretty self-explanatory, as is paragraph 3. Paragraph 3, screw scroll down if you don't have it in front of you. Paragraph 3 is basically giving them the financial information. If you talk to the management company before you got the listing to get all the information about the building so that you could sound educated on your listing appointment, you always want to check back with them and make sure that the numbers they gave you 2 months ago haven't changed. But assuming they haven't changed, it's easy to put these things in here. You know, sometimes there are more than one association. Sometimes you'll have 2 condominium buildings and then they have a common area for the recreational facilities that's actually an HOA. So you'll have 1, 2, 3 things to fill out. Let's see. Let's spend a lot more time on paragraph 3C. This is the one that trips everybody up, so I want to go through paragraph by paragraph. C1 says, seller represents that seller is not aware of any special or other assessment that has been levied by the association or that has been an item on the agenda or reported in the minutes of the association within 12 months prior to the effective date. So it doesn't have to be an issued special assessment. It can even have been talked about. You have to disclose it. And if you don't disclose it, seller's on the hook for it. So if there has been a discussion about redoing the roof or redoing the balconies or redoing the pool deck or anything else, you type it in there and you just say, yes, board has discussed the possibility of doing this, nothing's been issued, and it will be the buyer's responsibility if a special assessment is issued between the effective date and the closing date. Clear as that, okay? Put it on there, disclose it, and then the
Can I
buyer
say-
can't come back.
Sorry, just say one thing.
Yep.
If you're having trouble getting information from a condo association and you explain that one line, like we're dealing with a condo now and it's an absentee owner, so he gets information from the condo association and he never reads it. If you explain that one line, that if we don't disclose anything that's even been discussed, you are going to be responsible for it, I promise you that condo owner, he's gonna get on the condo and get you all the documents you need, because he doesn't wanna be on the hook for it.
And I always do a conference call. Say,
Right.
listen, I'm happy to be the one to say what I want, but I need you on the phone because they're not gonna talk to me. And so you get that person on the phone after having explained that this is all 100% your liability.
If we don't
If
know
you don't
exactly.
disclose it, even post-closing, they're gonna come after you if it's a month after the closing date.
Yeah.
Okay,
I have a question.
Yep.
And this is something that could be on the meeting of minutes, right? Like, cause my question is, how would they know?
they go to the board and they say, I'd like copies of all the minutes. I wanna know if this has been discussed. And some board member says, of course we discussed it. I raised it 3 months ago.
Got it, okay. Thank you.
Yep. Now I've had some associations who don't keep minutes and have tapes, and literally at the, used to be the Trump Towers, now it's just called the Towers. I had to go through audio tapes for 12 audio tapes. It was actually 24 because they were long board meetings, and I had to listen to all of those on behalf of a client who was a buyer, and sure enough, the guy was so happy to have paid me $3,000 to listen to the stupid audio tapes because it had been mentioned in the meetings, and we were able to play that tape for the seller's attorney, and they wrote us a check for $85,000. So very real circumstances here. Larry.
Paul, I just want to confirm, so often I find myself helping buyer's agents with this document. This truly is the requirement of the seller and their listing agent, is it not?
It is. It is. Now, a lot of buyers try to submit a contract with all the terms filled out, and it's perfectly fine if the association is going to speak to a buyer's agent to try to put any information you can in there. And I've had buyer's agents who knew about a potential special assessment and wrote it in the opposite way and said, there's a special assessment that's been discussed at the board minutes, and it's the seller's responsibility, if it occurs before the closing date, to pay that in full. And then the seller comes back and says, well, if it's payable over 5 years, I'll pay whatever my portion is before closing and you pay the rest, and that ends up in a negotiation. But yeah. Okay, so C2 says, if there's a special assessment levied or pending as of the effective date, and they're disclosed above by the seller and may be paid in installments, then there's a box to check. Is it the seller or the buyer who pays the installments due prior to closing? Sellers check buyer, buyers check seller, and then there's a discussion. Okay, then here's number 3. If special assessments levied or pending exist as of the effective date and have not been disclosed above by seller, then seller pays in full. That's the one that trips everybody up. They don't see it, they don't look at it, and it doesn't say it has to be issued at closing. So that's the one where I've gone back 3 months later and got a check for $85,000 from the seller because they failed to disclose it. It was a pending special assessment before closing as of the effective date.
But wouldn't that have been on the estoppel? The title company should have caught that?
The estoppel will never say what's a pending special assessment. It only tells you if it's a special assessment. Now if you do an estoppel letter and you say, are there any pending special assessments, they may answer the question, but that's not something that a traditional estoppel letter would cover.
I had that happen recently with the roof. It was like right after we closed, it got finalized, but it wasn't finalized yet. So does the seller have to pay for that? Is that the seller responsible?
Yes.
Yeah.
Yep. And then 4 is if after the effective date, the association imposes a special assessment for improvements which were not pending as of the effective date, meaning they weren't discussed before then. This is the question that this gentleman had about, it just came up. There's a roof leak that started after the effective date and before closing. Seller has to pay whatever's due before closing, buyer pays after closing. And then a special assessment is deemed levied for purposes of this paragraph on the date which the assessment has been approved as required for enforcement pursuant to Florida law. So there's many times where the board issues a special assessment, but they don't have the ability to. It then has to go to the membership for a vote. And people scream and yell and say, no, that's an approved special assessment. Well, no, it still had to go to the membership. That's gonna take another 30 days, and it's only approved at that moment in time. Okay? And then there's a funny one, C6, C Roman numeral 6, and that's for people, and this happens all the time with New Yorkers. They're used to having to give up a portion of their reserves in the co-op building. So for example, if everybody has put in $50,000 to the reserves and there's $5 million sitting in the reserves, the buyers say, hey, wait a second, that goes with me. That's part of the building ownership. That's just like the light fixtures in the building. That's so that we have enough money to meet our needs over time. And the sellers turn around and say, no, I put $50,000 in, it hasn't been spent yet, I want that back. Florida law addresses this in the condo rider right here. It stays with the building. Yep. So 3D is the litigation paragraph. If any of you who are dealing with a condominium that has recently done a transition from developer controlled to member controlled, this is where there is always a 558 lawsuit afterwards. The engineers come in, they find 6 defects. The transition board recommends filing suit against the developer for the bad construction. The developer turns around and third parties in all the contractors and subcontractors. A year and a half go by, the attorneys make $1 million each, and they settle for, the developer and the insurance companies settle for $2 million, turn it over to the association to make the repairs. If that's going on, you have to disclose it. If somebody gets a special assessment for litigation expenses that have been going on beforehand and it wasn't disclosed by the seller, again, the buyer's gonna turn around and file suit and say, you had an obligation to have told me that, I'm getting that money back from you. Okay, paragraph 4, sprinkler system retrofit. The sprinkler laws are life safety laws in the state of Florida, bless you.
Paul, just going back to that last point, do
Yeah.
title companies know of all litigation affecting the building?
No. No, there'll be no requirement for a title company to pull a litigation search on the condominium association itself. You could do that as agents. You'll have the name of the association, you go to the civil litigation at the clerk's office, determine that, but the seller should know and should disclose. And when you're going through the condo rider with them, you say to them, if you better ask, because if you don't disclose, you're gonna be liable for it.
Thank you.
Sure. Paragraph 4, sprinkler systems. These are life safety issues. All other issues with regard to code are usually grandfathered in. Meaning if you built a home in 1995 and you built it to the 1995 code, and the code changes over the years for windows, roof structure, other types of improvements, you don't have to keep ripping the house apart and putting in new windows every time the code changes. It's grandfathered in. Life safety issues in a condominium are not necessarily grandfathered in because it's a major concern and a life safety issue. So the rule is that the association has to update if there's a change in the fire sprinkler system unless the building as a whole votes to waive it. And that vote needs to be in writing, and it needs to be by whatever percentage the declaration allows the unit owners to waive. And there's a requirement in this rider that says if you're a seller and the association has waived the retrofit, you need to give the buyer a copy of that waiver. It's another one of the documents that you have to supply. So you have to ask the management company, have there been any waivers of any fire sprinkler system updates? If so, I need a copy of that to give to the buyer. Some of the associations that keep really good records already give that to you when you ask for the building package, but most don't. Most, you have to ask specifically for that. Okay, now we're getting into the disclosure issues. Up front, I asked you, when you're talking to the management company, what documents do you want to ask for? You want to ask for the documents that are in paragraph 5 and 10. Paragraph 5 specifically reads, buyer hereby acknowledges that buyer has been provided a copy of the current declaration of condominium, articles of incorporation, bylaws, rules and regulations, the most recent financial statement. So the most recent annual financial statement at this point in time would be for what year? Nobody's got their 24s done yet. Has to go to the CPA, has to get finalized. They won't have those until March at the earliest. So you have to give them 23. And you say, these are the most recent. And people will say, no, I want the 24s. I say, I'll give them year to date, give them to whatever they've given, but they're not finalized and it's not the most recent financial statement. And you have to give them the annual budget. And then there's always this frequently asked questions and answers document. Sometimes it's called the Q&A, questionnaire, various forms. Some buildings don't have it. If the building doesn't have it, I encourage you to get an email from the management company saying, we do not have this document, we've not prepared this document. It's supposed to be prepared. There are some buildings that haven't, because they don't want to get sued. But you just want to cover yourself and have something in your file that says, I asked for it, they say they don't have it. Again, you want to give that to them before the original listing. Just send it to them, put it on the MLS listing as attachments, as a link, but give it to that other agent so that they're responsible to give it to their buyers. And ideally, every single time you want to check box 5, which is weird, it says C, it should say A. It's a mistake on the rider that they just came out with. But you want to check box 5C, and you don't want to check box 5D unless you have to. If you have to check box 5D because your seller hasn't gotten you those documents, or you haven't been diligent enough to get those documents yourself, check box 5D, but you better tell your seller, I asked you for these up front. We don't have a complete set. The buyer has a right to walk away at any time until you give them every one of those documents and 3 days pass. So don't be disappointed if the day before closing, some lawyer like me writes a letter on behalf of the buyer and says, hey, I'm so sorry to do this to you, but you never gave us the 2023 financial statement. My clients decided not to move forward with the deal. Please send us the money back. And then the seller screams and yells at you, and you encourage them to talk to a real estate attorney, and the real estate attorney says, you could spend $50,000 fighting this, but you're gonna lose. I'd give them his money back, learn your lesson, get the document for the management company. Okay, so that's these two. Now we're gonna turn over to paragraph 6. If you're, and obviously if you're representing the buyer on one of these deals, you want to check the other box, that I get the right to cancel until 3 days after I receive every one of these documents. Paragraph 6 says, I'm either requesting it or I'm not requesting the documents. Again, if you're representing a buyer, you want to say I'm requesting it. If you're representing a seller and you've already given all the documents, you want to request does not request because you've already given it. You don't want them to say they haven't gotten anything. And same thing with 7. Buyer received a copy of the documents on such and such a date. So if you emailed the cooperating agent with a link to all the documents 2 days before the showing, you want to put that in here. I gave this to them on February 8th. Paragraph 8, self-explanatory. If there's a parking space, if there's a garage, if there's a storage space, if there's a dock, you want to put that in there. You want to write the number. What do you also want to know about all of those items? You want to know,
Where are they?
where are they? Is it paragraph, is it parking space number 7 covered? I put parentheses covered. You also, what else you want to know?
It's deeded to the place.
Yeah.
Exactly. You want to know how they own it. Is it a limited common element? Is it a deeded? Is it at the discretion of the board? I've had clients absolutely furious because the condo rider says I have parking space number 7. It is right next to the door. It's the best parking space in the whole condominium. And when they show up for their orientation, the day that they're about to close, the guy says, great, here's your parking space allocation number. It's 36. It's all the way at the end of that row. It's outside. And people say, I'm not closing. I didn't want to buy a space with an outside parking area. How can this be wrong? Well, it wasn't wrong. That was a seller's spot, but the association determines who gets what, and they only gave spot number 7 because she was a 93-year-old lady and couldn't walk very hard, but they had always assigned this unit that space out there. So those are the kinds of questions you want to ask up front so that there are no surprises.
Can you put in TBD if the seller doesn't know the number?
If the seller doesn't know the number or doesn't know how it's allocated, you want to talk to the management company. If they don't know, then you put TBD and you have to investigate during the inspection period.
Thanks.
Okay, paragraph 10, 11 are the new additions. Who's required to have a milestone inspection report? Anybody?
Condos more than 3 stories and higher, 25 years and older, and 20 years if they're within 3 miles of the beach.
Good.
15.
And after they do the initial
10 years.
milestone, every 10 years thereafter. Okay?
Sorry, can we clarify that? I thought it was 30 years or then 25 years if you're 3 miles from the beach. Yeah.
Yeah, I think it is 30 and 25 if you're from the beach. Yes.
Okay.
It's 3 miles.
3 miles from the
If you're
beach.
within 3 miles.
3 miles of the beach.
Right.
And it's required regardless if it's 3 stories or more, right? The age of the building, like it's not 3 stories or more or 30 years if the condo is just like a 2-story condo building.
So if it's a 2-story condo building, it's not covered.
Okay, so it's 3 stories.
If it's 3 stories, it's not covered, I think. No, it's 3 or more, so it is 3 or more.
Got it.
But if it's 30 years, 25 if you're within 3 miles of the, and I'm not sure if it's the beach or the coastal construction line.
It's the
Coastal construction line. Those are the thresholds for the milestone report. And if you don't have a milestone report now, you're late. I passed along to Matt the recent article in was it the Post or the New York Times? That said that there were a certain number of buildings that had asked for variances and they were told absolutely not. There are tons of engineers who could have done this for you. You're in violation. If you don't have it done in the next 6 months, we're gonna tell your building you're not occupied anymore. Everybody leaves. So they've been very serious about it. It's a law. It was supposed to have been followed. They gave them 18 months. And the people who didn't do it are in deep trouble. Many of those buildings didn't do it because they were in play, meaning there were developers trying to buy up the units and they were gonna tear down the building anyway, and they didn't wanna spend the money. And this was music to the developers' ears because now those remaining unit owners either need to sell to them and terminate the condominium in the next 6 months, or need to spend $250,000 on an engineering report.
Is it too soon or has anybody been vacated?
Nobody's been vacated yet. Yeah, that'd be August. Letters went out in January, giving them 6 months. So the turnover inspection report, I talked on this a minute ago. Section 718.301 talks about turnover. When a developer sells 90% or more of the units, they have to turn over and allow a certain number of board members to be there. When they sell out completely, they have to have a majority of the board appointed by others. That's when everybody goes and gets the engineering report, the first engineering report. It's a voluntary report, but there's no turnover committee that's not had an engineering report. Why? Because I don't know who in the world would ever want to sit on a turnover committee. You're just putting a bullseye on your back for the rest of the association. And if you don't get an engineering report and let the developer off the hook, you're gonna get sued personally for doing that. So every building gets a turnover report. It's an engineering report that's basically the equivalent of a milestone report. and they use that to negotiate with the developer for credits as part of the turnover process. And the developer wants a waiver and release from everybody, for them and for all their contractors and subcontractors, and in exchange for that, they pay what they consider blood money and what the turnover committee thinks is too low an amount for the damage.
Is that for new construction?
Yeah.
Would you consider this a widespread protocol for these developers?
I don't know a building that's been CO'd in the last 15 years that hasn't gone through this process. And sometimes it settles before the lawsuit if there isn't much wrong. But most buildings in Palm Beach County have gone through it. And there is always something that should have been built better that could cause a problem down the line, whether it's the sliding glass doors aren't properly secured to the building, or the tension wires don't have the right tension in them, so they have to be retrofitted, or there's leaks, the caulking wasn't done right, and it has to be re-gutted, re-caulked. Those are the most common things, but like the Coulter just paid $18 million at the, what's it called, the Ocean Club up in North Palm Beach. And they paid $18 million. What's the next thing that Coulter did? Notified the village of North Palm Beach and said, hey, we just paid $18 million because they said the building was gonna fall down. You better make sure they fix it. Because they thought the building was just gonna put the money in their pockets and not do a thing about it. Sure enough, the building didn't take any immediate action. And the village of North Palm Beach wrote the association a letter and said, I have a copy of the engineering report you submitted, which is a very serious engineering report, and I'd like to know in the next 30 days what you're doing about this. And now they've been fighting about what they actually need to do. Surprise, surprise, the building is saying, well, we don't actually have to do all of that stuff. And the village is saying, oh yes, these are life safety issues, we agree with you, and you have $18 million in your pocket. So bid it out and get started. When they went to bid it out, guess what the amount was?
36.
$28 million, $10 million more just in the year between the settlement and the actual bid price.
So how widespread is it that developers are taking over projects for redevelopment purposes?
Let's see, there are 4 buildings in West Palm that are in play right now. 40-year-old buildings, values, that's on a great piece of property. There are 3 buildings in South Palm Beach that are in play, 2 that have been taken over. So it's common.
And you expect that to be on the rise?
Yeah, absolutely. Now that the reports are in and people know what damage they need to fix, and they have a building that's 40 years old and all of the original owners are either dead or in their 90s, they don't want to live through a massive renovation. They don't have the money at this point. They've spent 40 years spending down their inheritance or their cash that they saved during their lifetime, and they don't have $800,000 to put in anymore. So what do? Developer comes along and says, I'll give you X million dollars for your unit, and you need to vacate, or you can rent back for a period of time until I'm going to demolish the building. People say, great. Yeah.
I'm sorry, you have a minute. So I just want to be clear, when is the turnover inspection required? When it's only new construction?
So it's not required.
Okay.
It's strongly suggested for the turnover committee to get that engineering report. I would say legally it's negligence if they don't.
Okay.
But if they do a turnover report, it needs to be given to the buyer.
Got it.
You can't keep a report like that in your pocket with valuable information that the buyer should have and not disclose it to them.
Yes, it's for new construction, is being turned over from the developer to the association.
Thank you.
Okay, so you've got the milestone inspection, you've got the turnover inspection report, and then the third new concept is this structural integrity reserve study. Does everybody understand what that is? So for years, buildings were having an annual vote to waive the reserves. What does that mean? Well, every building is made up of a bunch of different components. The roof, windows and doors, pool deck, garage, elevators, the electrical system, the plumbing system, elevators, lighting. All of these components have a lifespan. A roof, if it's put on correctly, should last 20 to 30 years, depending on the type of roof. Maybe even 40 years, depending on whether it's commercial grade. The AC systems, 10 to 15 years. Electrical should be 30 years. Elevators, 10 to 15, depending on what type of equipment you're putting in. Balconies, if it's near the ocean, 10 years max. Salt's gonna corrode that, gonna get into the rebar, gonna rust. You gotta replace those every 10 years. So what an engineering firm does is comes in and they evaluate the current status of all of those items. And they say, given the age of the roof and given the wear and tear on the roof, I think you have 6 years left. And the cost to do a new roof in 6 years, we estimate to be $450,000. Therefore, we're gonna divide $450,000 by 6 for this one component. And they're gonna come up with that number for the building, and then they're gonna do that for each other element of the building, the pool deck, the this, the that. And they're gonna come up with a number that needs to be in the reserves so that as things come up and as things need to be repaired or replaced, you've got the money in the till to do it, okay? And that's the concept that the state has now enacted into law, is that from here forward, you have to fully fund reserves so that you can replace things as needed. What was happening in the past is that the statute allowed people to waive, as long as you had a majority of the association waive it. Everybody said, we'll pay the special assessment if we need to. Let's not get crazy. There's no reason to put $1 million in an escrow account. I might sell my unit in 3 years. I don't want to put all that money in there because I don't get it back when I leave. And so over the years, they had waived and waived and waived to the point that they have so little reserves that when they did have to make a major repair, the cost of that repair would be so prohibitive that the board couldn't get any approval for it. And now the board's stuck in a horrible situation, just like Surfside, where they had gone to their members beforehand and said, we need to replace this roof. We need to replace the leaking pipes that are leaking water into our elevators and causing mold throughout the whole building. And the cost per unit is just gonna be $280,000. And the people said, you gotta be kidding. I only paid $180,000 for my unit. I'm not paying another $280,000. You can forget it. Now, the board members should have just resigned and should have had no board at that point instead of getting sued for all they had. But that's the situation that many associations were starting to work themselves into. And the state has turned around and said, no more waivers. You can't waive. And you have to have a report that's issued by December 31st of last year that tells you what you need to have in the till. Now, the good news is you don't have to fund it today. Okay, so if there are 0 reserves in the building for 2025, you just have to take that year's allocation for fully funding and put that in the till. So if you need 18 million, and they say, well, going forward for every year in the future, you need to fund 650,000 into reserves, you just have to put that 650 in. You don't have to put the entire 18 million in today. But every year in the future, we're putting $650,000, and it increases over time, depending on what the reserve study says, so that in 10 years, you will be fully funded. Now, is that gonna force a lot of people to sell? It sure is. There are a lot of people who don't have the money to be able to fund their portion of that $650,000. And you all should be out there farming in those areas. Building that's 25 years or more. Somebody who you know from past experiences in the building hasn't fully funded reserves. Those buildings are ripe for developer takeover. Those buildings are ripe for elderly residents to say, I'm out, I'm selling for what I can. This condo rider is an attempt to protect the buyers from those sweet old 92-year-old couple who are trying to defraud the buyer and not tell them about these problems. These are forcing them to provide the reserve study that says, guys, next year, the association fees are going up by 300% because we have to start funding reserves. So you can't just tell them, oh yeah, our condo fee is only $1,200 a year in 2024. You have to tell them, it's now $4,000 a month in 2025. So this is gonna require the disclosures. There are a lot of sellers who are gonna have to sell for a lot less than what they thought they were gonna have to sell because buyers are going to devalue the price of the unit by their financial obligations going forward. That's the big thing to understand about paragraph 10. That is gonna be a game changer. Okay. And you understand, you go through and you check these boxes as applicable. Paragraph 10 says, is a milestone inspection required? Yes or no. If it's not required, or if it has been required and hasn't done it yet. That's almost worse, right? If you see that box, you say, I'm out. I'm not coming back to this building until there's an actual study.
Is a building allowed to fund 50% this year and 100% next year?
No, but the law didn't come into effect until December 31. So what a lot of association lawyers were advising their clients to do is set the 2025 reserves before December 31. So the statute just said you have to start, as of December 31, you have to start allocating as of the new statute. So there are a whole bunch of buildings that moved it up to November meeting, moved it up to the beginning of December, and set their reserves under the 2024 laws, which didn't require 2025 funding.
Thank you.
It's gonna catch up to them next year. I was just reviewing a condominium, city side in West Palm Beach, in case anybody's looking at that building, and that's what they did. And I had to say to the client, you know, you really need to ask, and we really need to look at the reserve study to know what this number is gonna jump up to, because as of this year, they've skirted their obligations for 2025 by enacting their budget a month early. And they're not gonna be able to do that next year. And
The banks won't lend.
Yeah,
Not only that, you have to be really careful when you're comping a condo in a condo building, because you have to take all of this into consideration. You know, when the seller says to you, oh, my neighbors all sold for this, this, and this in the last year, year and a half, 2 years even, well, a lot of this wasn't in effect. So now you have to look at what are the coming assessments, the pending assessments, so you're not always comparing apples to apples anymore. So you have to know all of this before you can even properly price a listing there.
and it's really tough because the sellers are hoping that
Right.
you
They
don't
think
know
they're
any of
gonna
this.
get- Right.
And there'll be plenty of agents who don't know this, and they just look at the comps and say, oh, I can get you this. And you have to be the one to say, they can get you this, but you're gonna get sued post-closing.
Or if
You
you're,
can't close your eyes to
or if
this.
you're comparing to the building next door, which already went through their 40-year and already went through all this, and they've already been done with assessments, and your building is just starting, and even though we had a situation, in West Palm too, there's 2 sister buildings, one's done, one's not. So even though they're the same exact floor plan, same unit, you're not gonna get what they got in the other building, because they didn't have any of the assessments. So you really have to do that research, not just on your building, but the other buildings that you're comping.
A lot of these concerns are still valid for associations of villas and townhouses as opposed, you know, we're talking mostly, you're thinking about multi-level condos, but what about condo associations of villas?
So villas, which are traditionally 2 stories, aren't covered.
Well, villas would be 1, 2, town would be 2, but yeah.
Yeah, those wouldn't be covered by the milestone or the structural integrity study because they're not 3 stories or higher.
So the reserve problems aren't a concern of theirs?
Correct.
Okay.
Now, should it be a concern as you're raising? I mean, you're still gonna
There's
have to
still gonna be
replace the roof at some point.
Right, there's still concerns for buyers, and the buyers are still gonna wanna see the budget and the financials and know if there's any coming assessments, because even though, but it's just not required by Florida statute.
Yep.
If you had a buyer buying in a condo, even if it was a villa, you would still wanna make sure that they reviewed all of the same information.
And just give them notice that these are issues, there's a reason they enacted these rules for taller buildings, and they still apply equally as true. Somebody else?
So, you know how there's a section that you can check off for each one that it's required, but it hasn't been completed yet? In that case, which I'm sure you're gonna go over in the next page, but what would we check off? Because then the buyer's not being provided with a copy of the reports. You know how we can check off, like the buyer has that 3-day period to be provided with the reports, and then there's the other section that talks about the documents being received.
Yep.
So in that case, would you just leave it blank, or?
Yeah,
So you mean required but not completed?
Yeah, like if,
so if it's one of the buildings in Palm Beach County that hasn't done what they were supposed to do, I would turn back to the seller as the listing agent, and say, I really don't think you should expect to be able to sell your property at this time. And I'm gonna check this box, but whatever idiot is gonna say okay to this seems absurd to me. And we'll do it if you force us to do it, but I would rather see you spend the time and money focused on getting your management company to get that report issued and present it to the buyer. And at this point, you know it's only a couple of months away, or else they're gonna lose everything. They're gonna condemn the building. So
thank you.
there shouldn't be too many people in that circumstance right now.
Okay.
So Paul, I have a question. Us as agents, how can we protect ourselves? Do everything through email with the seller and the association and keep that in a file, just
Yeah.
in case?
Yeah, I think you take this condo rider very seriously. You document everything you've done. You put as much, it's tough to say because the sellers always want you to do everything. But the reality is that the sellers have to be told, the association management will not deliver the documents to me. They'll deliver them to you and you forward them to me. and I could be on the phone with you, but I need you as part of this process.
They
And,
charge too.
sure. Sure, well, a lot of the, First Residential doesn't charge,
GRS charges.
yeah.
But they don't charge the resident. They can't charge the resident. So what we've been doing is when we take a listing, I give the seller a list. Here's the documents we need and here's my card. Go to either email your property manager or go to the property manager and say, these are the documents we need, can you email them to my agent? And most of the time, we will get them. They have to request them, and if they request them, and like Paul said, most of the time now, a lot of the documents you need are on their resident portal, so they can log in and download them for you. If there's anything that's not, then they have to request it, but I've been putting it back on my seller, at least to ask the first time, and then if we don't get it, I will follow up.
And if you follow up and you don't get it, then the agents that I know have turned back to the seller and say, why don't you call Paul and have him write a statutory letter. 718 requires that they provide these documentation within a certain amount of time. And if they don't, then the association has to pay their attorney's fees to go to court and require it. And I've never had a circumstance where I've written my letter, as long as it's very clear, and it's probably the same letter she's using, I could copy hers and put it on my letterhead and say, I want these within the next 10 days. On the 11th day, I'm gonna file suit. You're gonna pay my $685 an hour to pester you to get what I need. And usually at that point, I always try to copy the board president, because they're all listed in SunBiz. I copy the board president, the board president calls me up and says, I am so sorry. I didn't know we were screwing around with you, and we'll get this taken care of today.
And they're all starting to come around little by little, like they all know that they have to provide this. So if the condo association is using one of the bigger reputable management companies, they're starting to set up websites, they're starting to get this listed in the portals for the residents, so you still might come, some of these smaller condos, you might be dealing with just the board of the residents who don't know, but they're starting to come around because they can't sell the units unless we have this information.
Yeah, especially if the purchasers are putting low money down, the banks are being incredibly thoughtful on their requirements for the management companies, and they're asking questions of the management companies they've never heard before.
Yeah.
I just did a termination of a contract today because somebody was putting 5% down, went to Wells Fargo, and Wells Fargo put this management company through an incredible ordeal.
Yes.
Asking questions about who on the association were delinquent, how many days have they been delinquent,
That's the condo question.
but asking more specifics than I've ever heard before about the CSRS. They wanna know, has everybody been paying the increased amount, not just the old amount? And they said, we won't even look at the unit until after the end of February, because we wanna know the 60-day delinquency after the numbers jump to a higher number. Because they figured out that half of these people aren't gonna be able to pay. And they wanna get ahead of it. And if half of those people don't pay, that means there's more of a delinquency for everybody else to have to pay. Yeah. So, all right, any other questions? Paragraph 11 is just a disclosure about what happens when you're in a multi-condominium building and the condo is just its own parcel and the common areas are governed by another association. So,
That would be like a condo that I've had in the past. We have like a private beach club, but it was like 3 different towers and they also was 2 different associations, but
yes.
every other condo had their own
association?
Yeah, every condo usually has their own condominium building, has their own parking deck, has their own pool, but they share the maintenance for the reception area, for the security,
Yeah.
for the landscaping, for the beach club. People were buying a condominium and weren't getting the HOA disclosure that says, oh, yeah, you gotta look at this other HOA. That's another $2,000 a month.
For me, I'm